thumbs up, thumbs up, everybody. I can't even fully finish one damn task because every time I look up, there is something else in the night sky. Yeah, I can't even look up, girl. Like when I work now, I have to just not even look. I have to just not even check my social medias. I have to just not even check my emails because I can't even get through one story entirely before something else is coming down the damn pipeline. You guys already know what we're here to talk about. Please thumbs up the video as you guys are coming in. Whether you're a Bush baby, whether you're part of the Replay Gang, whether you actively street for me in real time right now, run those thumbs up. It's free 99. It don't cost you nothing. And this is one of the best ways you can support any content here on this platform is by thumbing up. This also helps us to not have to deal with me stopping the show, reminding everybody to thumbs up. This allows us to continue to be fluid when we just get into the habit of thumbing up the video. Thumbing up not only helps the YouTube algorithm, but thumbing up helps support and sends out notifications to the rest of the crew member who sometimes don't have any idea that we actually are live because YouTube is so terrible with notifications. Okay, so we be having to go an extra step above and beyond them by running those thumbs up. All right, so if you guys thumbs up, the chat will grow, the stream gets bigger because you guys are letting YouTube know that y'all love this content, y'all love this content creator. His work needs to be out there. YouTube translates that as okay, this is desirable content, and they do their fair share of marketing and promoting and recommending and suggesting the live chat to other people who are not subscribed to us right now. All right, so that thumbs up is always very, very, very necessary. Shout out to all of the new supporters. Make sure you guys have your notification bell set to all. Last but not least, please share the stream out to whatever it is you have a digital community, whether that be a YouTube community wall, your Facebook, your MySpace, your archive of Twitter, Tumblr, or your personal OF. I don't really give a damn where you label ain't. Just let them whores know that we're loud, we're live, and we're certainly in color with no further ado. Let's go ahead and push on through. Okay.
I know a place where you can recharge your soul.
Baby, that's Consciouztv.
And in the midst of brokenness, he gon' see your asshole.
Baby, that's Consciouztv.
You gon' heal, you gon' laugh and catch a little shade.
Ooh, girl.
Y'all know he be slaying, y'all better stop playing. Come hear what he's saying.
Ladies and gentlemen.
Hey, all right, let me speak to the Conscious crew who are in the building right now. Starting from the tippity top of the live chat. Let me scroll up here. What's going on, Miss Dawkins? What's going on, Sexy Nessa? What's going on, Sin? Hey, Lawana. What's going on, Lovely 31 Blueprint? Hey, High Maintenance. What's going on, Mean Beans? Hey, Lady D. Hey, Ellie. What's going on, Easy Breezy? Period, honey. Makes you want to pop that puss on period. What's going on, Lorraine? Hey, honey, period. And we're back. Hey, High Mental Abilities. Hey, Love. Hey, St. Marquise. What's going on, Twins Valley? What's going on, Lanisa? Hey, Just Be Real. What's going on, Boo? What's going on? Real as it gets. So we got a lot of real folk in the building. What's going on? No power in the universe can hold me. What's going on? So hold on before you start. Let me go grab me some damn wine and a cigarette. Somebody else say, baby, this mess makes me want to drink, and I have not drunk in years, baby. Now, if Diddy, real as it gets, is going to make you turn into an alcoholic, baby, okay, don't be consuming this damn Diddy content, okay? Because we don't want you consuming liquor, baby, okay? And then you end up in a damn AA meeting as a result, baby, okay? So if it's all type of alcoholic spirits, you know, on this Diddy content, baby, you know, don't let Diddy do it to you, sugar, all right? We don't need him bringing down the rest of the damn community, baby. So you stay strong, real as it gets. What's going on, Madam? Hey, Kiwana. Hey, Coach Leslie. Hey, Love. What's going on, Lady Butterfly? Hey, y'all. Hey, Sharon. Your thumbnail. I don't know anything in the house. I don't have good, okay? Keep it that way. All you need is prayer and some Kool-Aid, okay? So I just want to come to you guys, because you guys know apparently Diddy has court tomorrow. As I told you guys in the very beginning, Diddy absolutely is going to exhaust all of his bail attempts. Okay. I don't know how many you technically get in federal court. But however many they are, baby, okay, he gonna exhaust them accordingly until he done reach zero. Y'all know another person who did this was unhinged with Cardi B's money. Okay, y'all know she kept appealing after the verdict was granted, okay, that she would owe Cardi, 4 million Mexican pesos. All right. And she finally exhausted all of her damn appeals. So now she's sitting on stuck, you know, Cardi is using Unhinged to make America great again and got that bitch on tour thinking she damn Bill Cosby, thinking she damn Martin Lawrence and shit, thinking she damn Eddie Murphy on stage, girl, okay, because she got to run Cardi her money, who is garnishing all of her damn checks, okay? Cardi is collecting, baby, all right? So Diddy, accordingly, is going to be exhausting all of his appeals. Now we do have the court files here. All right. So let's go ahead and read from one of his bail motions, girl, okay, which is going to be submitted to the Second Circuit U.S. Court of Appeals, damn it. All right, hold on, let me pull this up. I'm gonna share my screen here, honey, because the lawyers are lawyering, girl. They're lawyering. Hold on, how many pages is this, girl? Because y'all know, honey, I'm getting 56-inch braids put in my damn head, girl. I don't know. I done lost my damn Solange ass mind, girl. I'm out here thinking I'm Solange nose and shit, girl. Thinking I'm damn Brandy just sitting in my damn room, honey, sitting on top of the world with all this canacolonian fibers in my damn head. Oh, this is okay. This is okay. This is gonna be a cute little read. It's like 25 pages, honey. A little less than that when you get rid of the table of contents. Okay, so let's go ahead and read, girl, what the lawyers got in mind for Diddy. Do y'all think he gonna be granted, girl? Because y'all also know he got a new judge. They got rid of a Judge Carter. Okay, got reassigned to a new judge. So, will there be some leniency? We were speculating if the new judge, might have been, might have took a little nasty payoff, girl. Maybe, he's got a personal relationship to, some of Diddy's attorneys, because you guys know Diddy also he added on to his legal team. He didn't get rid of the red-nosed clown, Mark, but he just added on 2 other alleged high-powered ass attorneys, girl. So, Judge Carter being removed came without explanation and kind of came overnight out of nowhere, girl. So it's going to be interesting to see, girl, if third time will be the charm for the diddler, as they are calling him. All right. So let's get into this old nasty piece of motion, child. Bail may be denied only in a rare case of extreme and unusual circumstances, says the introduction. This case does involve extreme and unusual circumstances, but none that typically foreclose bail or warrant forcing Sean Combs to defend himself from a prison cell. What is extreme and unusual about this case is that Mr. Combs was detained immediately after he was charged, even though he has been in the spotlight his entire life, with many of his purported antics and episodes being widely reported in the press and known to law enforcement authorities. Okay? I need you guys to continue to run those thumbs up, honey. Run them up, up, up. Hey, everybody coming into the chat, y'all. Y'all thumbs up as y'all come in. Let me see, where was I? Indeed, hardly a risk of flight. He is a 54-year-old father of 7, a U.S. citizen, an extraordinarily successful artist, businessman, and philanthropist, and one of the most recognizable people on earth. The sensationalism surrounding his arrest has distorted the bail analysis. Mr. Combs was not released pending trial, even though he offered to comply with restrictive conditions that would have prevented any conceivable risk of flight or danger. The district court detained Mr. Combs in a conclusory, bare bones oral ruling, apparently because of unspecified concerns that he would obstruct justice and intimidate witnesses. Now, it's interesting that the attorneys are talking about unspecified concerns. Remember, in the indictment, they already have Diddy on recording, two different recordings, intimidating alleged witnesses, aka victims, trying to get them to change their stories. Remember, he called Kalina Hop of dirty money a trillion times over a 3-day period, girl, coercing her, making promises to her. And then she came out with her mummified statement following Don's lawsuit against Diddy, who is another member of Dirty Money and a previous member of his girl group, Danny DeCane. So they already got this man allegedly on audio, bribing, intimidating, extorting girl, obstructing justice. So it's apparently not as unspecified as this write-up would have it be. The government's arguments about the risk of obstruction were based on speculation. Once again, must be forgetting the alleged evidence in this case to support obstruction and intimidation, resting mainly on untested allegations about communications with witnesses. This is why I be slamming his attorney. So I'm just like, girl, did y'all read the indictment, boo? Did you listen to the press conference that the U.S. Attorney General gave, girl? They came into the indictment with evidence, with recordings, with audios. Like, it's not pure speculation. It's not them just throwing ish up against the wall, baby. Where there was smoke, they found some fire. And this is ongoing investigation. So they're continuing to allegedly find fire, aka his male prostitutes have come forward. They have submitted actual freak off footage of Diddy and other high profile individuals doing illegal drugs and doing all type of freaky ass ish, etc. Girl, the freaky ish ain't illegal long as it don't involve no minors and as long as it don't involve no incapacitated ass person who can't consent. But the whole prostitution situation is illegal, and the whole drug situation and narcotic situation is an illegal situation. So I just be wondering why the attorneys don't fill it in, because like obviously these are easy arguments for the courts to make in their rebuttals if the way y'all are even arguing his case doesn't even involve y'all attempting to even like work around what they are charging him with and the evidence that they already came into this case with on him. Nonetheless, the government's arguments about the risk of obstruction were based on speculation, resting mainly on untested allegations about communications with witnesses in civil cases and communications initiated by supposed witnesses and not Mr. Combs. The government even claimed his public denial of a former girlfriend's allegations in a civil lawsuit constituted attempts to obstruct justice. If denying accusations by civil plaintiffs could justify pretrial detention, the liberty protections of the Bail Reform Act and the Constitution, not to mention the First Amendment, would be meaningless. Throughout the bail proceedings below, Mr. Combs rebutted the government's profers, but without fact-finding or analysis, the district court endorsed the government's exaggerated rhetoric and ordered Mr. Combs detained. In doing so, the court committed legal error, rejected a plainly sufficient bail package, and violated its obligations under the Bail Reform Act. Mind you, when they arrested Combs, they allegedly found pink powder on his damn persons as well. Mr. Combs is presumed innocent. He traveled to New York to surrender because he knew he was going to be indicted. He took extraordinary steps to demonstrate that he intended to face and contest the charges, not flee. He presented a bail package that would plainly stop him from posing a danger to anyone or contacting any witnesses. In Diddy's case, what the attorneys are failing to acknowledge is that it is impossible for them to make that argument that somebody of Diddy's immense wealth, power, influence, and reach could be in any predicament, in any situation that would render him unable to be a threat. Even him behind bars, honestly, does not completely prohibit him from being a threat to witnesses. Long as he has access to a phone, he's able to do that. I mean, we're not going to act like there aren't total criminals behind bars right now who are still kingpins, who still put hit out on people's heads, who still carry out assassinations. I mean, how do they think criminality happens from inside the prison walls? So, this is an absurd argument on their end that somehow Diddy's bail proposals could somehow promise that he would not be of a threat, that he would not menace, he would not terrorize, he would not gang stalk, and that he would not cause any harm or distress to anyone. That's a ridiculous statement. Using the Bail Reform Act, liberty is the norm and detention prior to trial or without trial is the carefully limited exception. Mr. Combs is entitled to release under federal rule of appellate procedure, those procedures there, and immediate release pending deposition of this appeal under federal rule of appellate procedure. Whether the district court's obstruction and witness tampering conclusion lacked a factual basis and misapplied the law. Rather the district, here are the issues presented. Whether the district court erred in concluding conditions would reasonably assure the safety of any other person in the community, whether the district court erroneously felt to make the factual findings required by the Bail Reform Act and weigh the required statutory factors. Background. Long before his indictment, Mr. Combs took numerous steps demonstrating his trustworthiness and commitment to proving his innocence in this case. Since early 2024, he understood he was the target of a serious federal investigation. Nonetheless, he immediately directed his counsel to proactively reach out to prosecutors. He subsequently took extraordinary steps to voluntarily surrender and try to satisfy any possible government concerns about flight risk. Now, mind you, when they raided the nigga's home in Miami, he was literally at a damn airport about to board his private damn jet. Make sure you guys are thumbing up the video as you guys are coming in. Thank you so much. Months before the indictment on March 13th, 2024, Mr. Combs' counsel emailed the assigned AUSAs to introduce himself and asked to speak with the prosecutor so he could provide information about the case. He renewed the request 5 days later. The government never responded. On March 25th of 2024, the government executed search warrants at Mr. Combs' residences in Miami and LA. Mr. Combs was personally searched, as was his airplane. Counsel agreed to accept service of 2 grand jury subpoenas to Mr. Combs' businesses. On April 1st of 2024, defense counsel took custody of Mr. Combs' passport and advised the government that it would not be returned to him and he would not leave the country. Counsel also promised to advise the government in any advance of any domestic travel by Mr. Combs and did so, sharing his whereabouts and travel plans at least 9 times from May to August of 2024. Mr. Combs also put his private airplane up for sale because of the investigation and notified the government accordingly. And he advised that multiple relatives, including his mother and 4 minor daughters, had given counsel their passports. Mr. Combs also paid off the outstanding debt of $18 million on his $48 million home on August 20th of 2024 so it could provide unencumbered security for any future bail package. During this time, counsel continued conferring with the government regarding its grand jury subpoenas. Counsel withdrew prior counsel's motion to squash conducted voluminous searches, and produced over 144,000 pages of documents. Finally, when counsel informed Mr. Combs that his arrest was likely imminent, he immediately relocated to New York City from Miami on September 5th of 2024 to surrender. At that time, his counsel informed the government of his intent to surrender. Counsel offered to continually share Mr. Combs' location with the government and asked for a time when Mr. Combs could surrender. Despite Mr. Combs' offer to surrender, on September 16th of 2024, the government arrested him on a 3-count indictment charging racketeering conspiracy, sex trafficking, and interstate transportation to engage in prostitution. The government claims the core of this case is freak-off activity, which allegedly involved elaborate and produced sex performance that Combs arranged, directed, masturbated during, and often electronically recorded. Mr. Combs believes that the evidence will show that to the extent such activities occurred, all individuals who participated were adults voluntarily engaged in consensual sex. Mr. Combs was arraigned on September 17th of 2024 before Magistrate Judge Robin F. Tarnofsky and pled not guilty. The government sought detention, arguing that Mr. Combs presented a risk of flight, danger to the community, and risk of obstruction and witness tampering. Despite Mr. Combs' robust bail proposal, that judge with that crazy ass last name detained him. Mr. Combs appealed. The district court Carter held a bail hearing on September 18th of 2024. The court began by noting that the government primarily seeks detention based on a risk of flight and the danger of obstruction of justice or witness tampering. The court indicated that based upon the parties' written submissions, its lesser concern was risk of flight, and its bigger concern dealt with the danger of obstruction and witness tampering. The government reiterated the indictment's allegations and only vaguely alluded to possible witness testimony and evidence, primarily relying on a widely publicized March 5th, 2016 video of Mr. Combs depicting a domestic violence incident with a former girlfriend called Victim 1 in Count 2. The government also mentioned text messages and phone calls between Mr. Combs and potential witnesses, primarily witnesses in civil lawsuits filed against Mr. Combs. The government went so far as to argue that Mr. Combs' public statements that a civil lawsuit was riddled with lies were attempts by him to obstruct justice. The defense rebutted each of the government's arguments regarding the March 5th, 2016 video. Defense counsel explained that Mr. Combs and Victim 1 shared a 10-year romantic relationship that was often mutually toxic. They're talking about Cassie in this case. Counsel noted that countless written communications tend to negate any lack of consent and any coercion regarding their sexual activity, and cited evidence showing a long-term loving relationship that became strained by mutual infidelity and jealousy. The overwhelming written communications describing their consensual sexual relationship included communications concerning their mutual decision to bring a third party into their intimacy. The violence depicted in the March 5th, 2016 video was entirely separate, stemming from jealousy from infidelity 8.5 years ago. So they are trying to allege that Cassie was a disgruntled, jealous, raging ex. However, Cassie was the one walking away. Okay? At that part. You guys thumbs up, up the video. She wasn't the one dragging Combs up and down the goddamn hallway. She wasn't the one throwing vases and objects at him. She wasn't the one drop kicking him and stumping him while he was on the goddamn ground for her to be so also mutually toxic and so, in fact, jealous. Defense counsel cited interviews with half a dozen male escorts who participated in the freak-offs described by the government and confirmed they never witnessed anything remotely non-consensual. Counsel explained that Mr. Combs and Victim 1 both suffered from serious drug problems at the time of the video and subsequently participated in rehab before eventually separated in 2018. Counsel further explained Mr. Combs' communications regarding Victim One's November 2023 lawsuit. Years after the couple's separation, a lawyer representing Cassie demanded a $30 million payment from Mr. Combs in exchange for the rights to a tell-all book that Cassie had supposedly written. When Mr. Combs refused, Cassie retained new counsel who filed a lawsuit which was quickly concluded with a very large settlement. This prompted a torrent of other lawsuits, although Mr. Combs communicated with others about the conduct alleged in these civil suits, including individuals the government now characterizes as victims. At the time, he knew nothing about the SDNY's investigation and was not engaging in any attempted obstruction. The government had no response other than to say that Mr. Combs certainly suspected the possibility of an investigation, citing his statements he was not supposed to be speaking on the phone. Defense counsel also rebutted the government's other obstruction and witness tampering allegations regarding a civil lawsuit filed against Mr. Combs on September 10th of 2024. After the suit was filed, Mr. Combs spoke with an individual the lawsuit identified as a prominent witness to his alleged violence. The individual in question was very upset about the publicity and wanted to make a public statement that her personal experience diverged from the lawsuit's allegations. A counsel explained this witness was represented by the attorney at the time of the communications and could be an important defense witness with whom the defense will likely continue speaking. Counsel further explained that Mr. Combs had, with counsel's blessing, called potential defense witnesses to let them know that counsel would reach out to speak with them. Notably, search warrant affidavits disclosed to the defense on October 7th of 2024 confirmed all of this blacked out information, but during its proffer to the court, the government concealed this fact, which completely undermines its claims that the timing of the contacts with the witnesses in September 2024 suggests obstruction. Although the government vaguely described contacts with two grand jury witnesses, it preferred no evidence of any threats or intimidation. The government could only state that there were 14 total contacts between Mr. Combs and one witness and another witness who was contacted multiple times. Defense counsel explained these contacts involved no obstruction or witness tampering. For example, one witness contacted Mr. Combs, not the other way around. She reached out to Mr. Combs and told him, "I'm a grand jury witness." Wow. After Mr. Combs informed defense counsel, he was instructed not to contact the witness anymore and didn't. Of course, the defense explained it must continue to interview witnesses to conduct a responsible defense investigation. Mr. Combs proposed a robust bail package with extremely... Okay, so before we get into that, the attorneys are basically alleging that, hey, you guys can't hold Sean Combs accountable for any alleged obstruction or witness tampering because any of his alleged tampering or conversations with alleged witnesses took place before this indictment. It took place before the investigation, and that he was in his legal right to correspond in whatever way with people who had pending or were threatening him with civil actions, etc., blah, blah, blah. So the courts are out of order for using these conversations or exchanges against him after the investigation was led, because they're arguing that there's no legal grounds for the courts to have held him accountable to an investigation prior to the investigation. But once again, you have the issue of Kalina Harper and him calling her a trillion times before she made her statement, and that was definitely after his ass had been indicted and in the days following his actual arrest. In addition to the rebutting the government's proffer, Mr. Combs proposed a strong bail package prior to the district court hearing. The proposed conditions included a $50 million bond co-signed by Mr. Combs and 7 family members, secured by Mr. Combs unencumbered, a $48 million home, and his mammy's house. Travel restricted to the Southern District of Florida and Southern and Eastern Districts of New York. Home detention with GPS monitoring. Providing Mr. Combs' passport to pretrial services, retaining the passports of 5 other family members, including his newborn, continued efforts to sell Mr. Combs' airplane, and a restriction on bringing the plane to any district in which Mr. Combs is located, restricting all visitors to Mr. Combs' residence except family, caretakers, and friends not considered to be co-conspirators, with no female visitors except family and mothers of Mr. Combs' children, with a daily visitor log shared with pretrial services. No contact with known grand jury witnesses, weekly drug testing by pretrial services, and all other standard conditions of pretrial supervision. Once again, if you guys are in the building, please thumbs up, 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 up until it is stuck. During the hearing, counsel supplemented the package with the following additional conditions, specifically designed to prevent any witness tampering or obstruction, which would be 24-hour monitoring of Mr. Combs by a third-party security force, SAGE Intelligence, which employs former federal and state law enforcement officers. That wouldn't bring relief to anybody, considering that Combs allegedly has the LAPD, the Florida PD, New York PD in his back pocket. Hell, even Tony Busby, the attorney that's representing 120 of Diddy's alleged victims, also a lot of them made police reports, and there was no follow-up, there was no investigation, there was no questioning of Mr. Combs as it related to those police reports. So yeah, no access to the internet, no phones, restrict visitor access to only a pre-approved list of visitors to be shared with the government pretrial services and the court. Video camera monitoring of Mr. Combs if necessary. Definitely would have been necessary. In addition, during the hearing, defense counsel repeatedly made clear Mr. Combs would accept any other conditions the court deemed necessary. Counsel offered to put together a protocol so that the court is absolutely satisfied and comfortable that there is quite literally no way that Mr. Combs would be able to conduct any kind of contact. That's not going to be the case when a part of your bail package is that y'all at least want him to be able to have over friends and have over relatives, and obviously he's going to have access to staff. However, this is where his power, his influence comes into play at, because the government, the feds, are indicting him on racketeering, aka RICO, which is organized crime, which Diddy's co-conspirators could even still right now be some of his friends who the feds have not yet also indicted, could be employees that have yet been indicted, and could possibly even be fucking relatives. All these people, anybody who's on his payroll, anybody that loves him is susceptible to acting on his behalf, even without him having to tell them to do so. This is what the feds don't want any chance and possibility of happening, because some of these alleged witnesses and victims, unlike Diddy, are not filthy rich. They don't have the means to safeguard themselves. They don't have the means to live their lives in a way that can protect them from these unforeseen forces that could become the agendas of Mr. Diddy, laid out by his relatives, his friends, and his staff. We'll do whatever needs to be done. Quote, we can have any protocol that your honor sees fit. We can do whatever your honor thinks is necessary. What the district's court ruling was. The court denied bail and granted the government's detention request at the end of September 18th of 2024 hearing, stating, quote, I find that the government has carried its burden of persuasion by clear and convincing evidence on dangerousness, both for obstruction and witness tampering, as well as danger more generally, even if the defense has rebutted the presumption by coming forward with their burden of production. The court stated it need not reach flight risk. The court further stated the government has proven by clear and convincing evidence that there is no condition or combination of conditions that will reasonably assure the safety of a person in the community, as well that Mr. Combs will not obstruct justice or tamper with witnesses. Absolutely. The court rejected Mr. Combs' proposed bail package and adopted the government's argument that under the proposed conditions, the defendant would still have access to employees and other individuals and thus could obstruct justice and intimidate witnesses through those folk through even coded messages if necessary. Once again, this is how ex-cons and current inmates carry out all type of hits and trafficking of drugs and humans outside of the prison walls. They talk in coded language. They have all their plugs. They are in relationship to COs. They're paying COs off. I mean, it goes down. The court made no findings of fact and provided no further indication why it concluded detention was necessary. On October 3rd of 2024, the case was reassigned to Judge Arun, whatever the hell that last name is. Rulings of law in bail proceedings are reviewed de novo, United States versus English, while historical facts are reviewed for clear error. The scope of review is slightly broader with respect to the ultimate determination that a defendant does or does not present a risk of flight or danger. Whether conditions will reasonably assure the defendant's appearance and the safety of the community is a mixed question of law and fact reviewed for the clear error. The clearly erroneous standard does not apply if the court has not made an error of law, in which case the court finding should be set aside. If, for example, the court does not consider the factors set forth in 18 U.S.C. in reaching its ultimate finding on the existence of non-existence of conditions, the finding will be subject to more flexible review. The court's findings will also be subject to a plenary review if it rests on a predicate finding which reflects a misperception of a legal rule applicable to the particular factor involved. The court has held that clear and convincing evidence that there exists a serious risk of obstruction or witness tampering can justify pretrial detention. But there was no clear and convincing evidence supporting detention here. The circumstances justifying detention in prior cases were completely different, and the court's contrary conclusion reflects a misperception of the applicable law. First, the government's proffer concerning alleged obstruction and witness tampering was too thin to support detention. The proffer highlighted 2 points: that the March 5th, 2016 video and Mr. Combs' alleged contacts with witnesses regarding the 8.5-year-old video. The defense robust competing proffer explained Mr. Combs' decade-long consensual relationship with Cassie, the video's context, and that both parties had subsequently participated in drug rehabilitation. And the witness contacts the government cited were minimally relevant or entirely innocuous. For example, the government emphasized that Mr. Combs had contacted witnesses, but these contacts were largely related, once again, to civil suits filed before the indictment, and most occurred before Mr. Combs even knew there was an investigation. These communications, the substance of which the government did not fully disclose, hardly reflect threats, obstruction, or witness tampering. Even with respect to the grand jury witness the government claims Mr. Combs contacted, the government could only vaguely represent that there were 14 total contacts between Combs and one witness, and that another witness was contacted multiple times. That was it. The government provided no further detail, nor did the government share how these witnesses even perceived the contacts. The government's silence on the point is telling, because the proffer was implausible on its face. While the government suggested witnesses have universally one-for-one expressed to prosecutors their extreme fear of Mr. Combs. At least one of these victims proactively reached out to Mr. Combs to tell him that she was a grand jury witness. And once defense counsel learned Mr. Combs was contacted by a potential grand jury witness, they immediately instructed him to cease any such contact, which he did. Clear and convincing evidence requires that the evidence support the conclusion with a high degree of certainty. That's another interesting thing, is that this man was contacted by someone who was drafted into being the grand jury. And what is to keep people who will make up the grand jury, or who will even make up the jury pool, to be fans of Combs, contacting him, his attorneys, who are, yes, supposed to practice law and be ethical, but we all know we're talking about human nature here, and attorneys don't be no better than their damn corrupted ass, guilty ass clients who will manipulate the facts, who will use that to their advantage. Because once again, when we're talking about juries and shit and trial, all it takes is for one motherfucker out of the jury to be unconvinced, to have questions, to be confused, to be unresponsive, and kabam, bitch. You get this long, drawn-out thing. You get a mistrial. You get all type of fuckery. So it ain't even looking good that one of the members of the grand jury reached out and contacted this ninja. I'm finna send you the 237-page exhibits after. Oh, yes. Definitely do that, chef. Consciouztv@gmail.com, honey, on period. Clear and convincing evidence requires that the evidence support the conclusion with a high degree of certainty. Okay, his legal defense is arguing that the U.S. government did not eliminate benefit of a doubt. That their argument is weak, is thin, is frail, just like unhinged edges, you know. So they're offering, they're like, look, girl, y'all, like, this was a boneless rebuttal. It was boneless, girl, boneless. The government did not meet this burden. The proffer provided no basis to believe Mr. Combs had threatened, intimidated, or otherwise attempted to tamper with witnesses, and fell far short of demonstrating a serious risk of obstruction or witness tampering in the future. In any case, the defense's competing proffer adequately rebutted the government's allegations, and at a minimum left the evidence in whatever the fuck that word is. Second, the court misapplied precedent. The cases the government relied upon are far afield. In Leon, for example, there are ample proof that the defendant had threatened two potential witnesses, including through explicit threats to his arresting officers, that he would get even, and to see to it they went on a very long vacation. The findings of threats rested on strong evidence in the record, including witness testimony at the bail hearing. And LaFontaine was a bail revocation decision under that, so a much lower burden of proof, probable cause applied. Even still, LaFontaine rested on actual evidence that while on bail, the defendant shredded documents, attempted to contact and intimidate witnesses, and lied in an affidavit to the court. The non-binding decision in the United States versus Bankman fraud likewise involved a bail revocation proceeding under the lower probable cause standard. In cases where the government's proffer is as thin as the one here, the risk of witness tampering or obstruction is not supported by clear and convincing evidence. Although this district court never explained its reasoning, it appears to have erroneously adopted the government's exaggerated rhetoric. There was no factual or legal basis for detaining Mr. Combs. He is entitled to pre-trial release. Pre-trial detention is permissible only if the district court finds that no condition or combination of conditions will reasonably assure the appearance of the person as required and the safety of any other person in the community, the court has no obligation to consider all possible alternatives to preventive detention, whereas here the court ultimate finding rests on a predicate finding which reflects a misperception of a legal rule. The court's decision is subject to a plenary review. The court erroneously rejected Mr. Combs' proposed bail package, which was plainly sufficient. The government claimed the proposed conditions do not speak to at all to Mr. Combs' risk of obstruction, as they still contemplate him having staff and visitors. But counsel adequately addressed these concerns at the bail hearing by proposing additional conditions. These more restrictive conditions prohibited internet and phone access and included 24-hour monitoring by well-trained third-party security personnel and video monitoring if necessary. The proposed conditions reasonably mitigate any perceived risk. The Bail Reform Act expressly contemplates releasing a defendant into the custody of a designated person who agrees to assume supervision. If the designated person is able to reasonably assure the judicial officer that the person will appear as required and will not pose a danger to the safety of any other person or community. There is no reason 24-hour monitoring by trained third-party former state and federal law enforcement officers could not prevent obstruction, particularly where the defendant will not have electronic devices and thus could not directly contact any witnesses. Courts have found similar proposals sufficient to encourage against obstruction, flight risk, and danger in past cases, and here are those cases listed here. Concluding proposed conditions reasonably mitigated danger to community and risk of witness tampering, because if a defendant is strictly confined to an apartment with electronic monitoring, there is no meaningful likelihood he will engage in any conduct constituting danger. Describing a comparable package as extraordinary in vacating and remanding for release on stated conditions. The district court rejected the proposed bail package for purely speculative reasons. The court stated the proposed conditions would permit Mr. Combs to obstruct justice and intimidate witnesses through employees and other individuals, and even coded messages if necessary. There was, however, not a shred of evidence that Mr. Combs had used third parties to tamper with witnesses through coded messages, nor did the government cite any evidence supporting this bold claim that Mr. Combs used intermediaries to reach out to people. Instead, their proffered example involved a direct contact, one that occurred in November of 2023 when the only pending proceeding was a civil suit. The government alleged that after Cassie filed her lawsuit, another alleged victim, also a girlfriend, initiated contact by texting Mr. Combs, who subsequently called her and recorded their conversations on another person's phone. This didn't involve an intermediary and is hardly evidence of obstruction. Even apart from the fact that Mr. Combs could not have contemplated any particular official proceeding at the time, why would a person engage in a witness tampering record engage in witness tampering, record the conversation? He was obviously recording the exchange to protect himself from further false accusations. Regardless, as a practical matter, the conditions are sufficient to alleviate any purported obstruction risk. The proposed package contemplated a pretrial approved visitor list, and counsel made clear it could be further limited in any way the court saw fit. The only necessary visitors are members of the defense team who obviously will not be assisting any effort to obstruct justice. To the extent family members are approved for the visitors list, security and video monitoring is sufficient to ensure against the purported risk of any attempt to indirectly contact a witness. The same would be true if employee visits were contemplated, but to be clear, there is no need for concern about employees and friends and the like. Mr. Combs will not request that any employee or friend be permitted to visit him, nor would it be necessary for him to speak with employees. For such conditions to be adequate, the Act requires only a reasonable assurance. Hold on, what? Mr. Combs will not request that any employees or friend be permitted to visit him, nor would it be necessary for him to speak with employees. Why would it not be necessary for him to speak with his employees? I'm so confused. For such conditions to be adequate, the Act requires only a reasonable assurance and does not demand absolute certainty. So they're arguing, girl. It just got to make sense, baby. Okay, we ain't got to make no 100% promises, baby. But you know, we just gotta. Our only burden is setting shit up in such a way that it makes our plight clear and cut that Mr. Combs is going to be reasonably supervised like a toddler, and that we're going to reasonably conceal and block off any avenue that could be used for him to abuse any potential witnesses and or alleged victims with. You know, we're not God, so we can't absolutely promise or demand absolute certainty. But, you know, that's not what the burden is. The burden is for us to look at the circumstances and once again, reasonably block off any potential bridge and avenue that could lead to any obstruction and witness tampering. 2, require the latter and deny release on conditions based on speculative doubts would only be a disguised way of compelling commitment. Indeed, this court has already rejected the theory that certain conduct is so extreme and aberrant and such that no set of conditions could reasonably assure the safety of a community. Here, the conditions proposed were adequate relative to the weight of the purported risk. Mr. Combs should be released because regardless of the government's untested allegations, the proposed conditions will reasonably assure his appearance and the safety of the community. The Bail Reforms Act's statutorily mandated procedures present Congress careful delineation of the circumstances under which pretrial detention is acceptable. Failure to follow these procedures or reliance on constitutes an error of law. The district court committed legal error by failing to make any factual findings or weigh the required factors. The Act unambiguously requires written findings of fact and a written statement of reasons for a decision to detain. This requirement is specifically designed to further the accuracy of detention hearing and is intended to ensure that the district court's reasons for its decision are sufficiently clear to permit meaningful appellate review. The Act further states courts shall take into account for factors in determining whether there are conditions of release that will reasonably assure the appearance of the person as required and the safety of any other person in the community. The factors include the nature and circumstances of the charges, the weight of the evidence, the defendant's history and characteristics, and the nature and seriousness of any danger to the community. These factors ensure the act is administered consistent with due process. Thus, the district court must consider factors as the ultimate finding properly can be reached only after their consideration. In the cases the government relied on below, the detention orders were supported by detailed factual findings and explicit weighing of the factors. In contrast, the decision here reflects a wholesale departure from the Act's requirements. The court made no factual findings and failed to weigh the statutorily enumerated factors, although robotic inclinations are not required. It is not at all clear what facts the district court used to support its decision, nor is it clear what evidence, if any, the court credited why or on what basis it rejected the defense's proffers, rebutting the government's claims, or how it made its ultimate determination. The absence of such findings is particularly troubling here because the government proceeded largely by proffer simply stating in the most general and conclusory terms what it hoped to prove. Although courts may rely on proffers, the exercise of the discretion should reflect an awareness of the high stakes involved. But here, the district court took no additional steps to ensure the reliability of the evidence. In Lafayette, and because counsel contested the government's version of the events with a competing defense proffer, the evidence was at minimum, that word there that I'm just not in the mood for to pronounce tonight, without meaningful factual findings and weighing of the evidence, the detention order lacked any basis. The court has reversed similarly defective detention orders. You can see here, vacating and remanding, where detention order contained only implicit findings related to risk of flight and no finding whatsoever on obstruction. Remanding, where district court failed to explain on the record the basis for conclusion. It should do so here as well. The conclusion is, for the foregoing reasons, the district court's detention should be reversed. The court should order Mr. Combs' release under the conditions proposed below or any additional conditions the court deems necessary. The undersigned counsel of record for defendant appellate Sean Combs certifies pursuant to federal rule, blah, 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 blah. The brief complies with the typeface and type style, blah, 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 blah. Girl, to be honest, I'm low-key kind of scared. I think this third bail appeal, I think it was actually written up well. With me understanding that, it's not their job to burden themselves with certainty, because no system can make such a burden or bear such a burden. But considering their bail package and the additional add-ons like the 24-hour surveillancing, visitors log list, restricted staff, no electronics, no Wi-Fi, no blah 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 blah. I actually feel like this is a very strong rebuttal. What I feel is going to be, and this is, this is good and bad, is the fact that even with everything presented here, the thing that's probably working against Sean Combs is not even the case itself. It's the color of his skin. He's a black man. He's going before he's going before pale ass judges. And, they have put black men behind bars accused of less. So a black man of this caliber, of this level of success and wealth and means under these circumstances, I do think that, if they might have sustained his detention, probably based on some racial undertones, even though I'm personally not mad at them keeping his ass there. With this new judge coming in, it's going to be interesting, because what his counsel just did is pretty much clocked, popped, and dropped the court's decisions to retain Diddy until trial. They called out specific inconsistencies. They called out the parts that the prosecutors did not make clear, that these arguments are, first of all, weak. A lot of them are unfounded. And even in the instances in which it's clear what they're saying as it relates to obstruction, these conversations happen prior to an investigation. And even in the conversations, there is nothing that remotely reflects obstruction or tampering or this, that, and the third, and blah, 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 blah. Like, they kind of didn't run, from anything. They dealt with everything kind of head on, and they kind of reverse Uno and threw it back in the court's face. Is that, there are parts of this shit that y'all didn't even explain at all, that y'all didn't even really offer an explanation to at all, which is very, 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 very telling about what's really going on here, which is that y'all are basically just making this decision because y'all can, not necessarily because y'all are following the literal protocol, and y'all are burdening y'all self with truly justifying why he should remain behind bars until trial. I'm going to be very curious to see how this lands on this new judge. We know that Judge Carter, which was the second judge that they threw the second bail appeal at, he agreed with the first ruling. He felt too that the courts had met their burden, etc. There was nothing to see here, and bail accordingly was denied. His counsel in this third bail appeal is letting it be known, bitch, like, y'all do know we can overturn it here, and they listed their fair share of other cases in the history books where a package like this was supported. They clearly defined what obstruction actually is, what proof of obstruction actually looks like and sounds like legally. So, yeah, I know about his security guard buying land close to the border, and we already know what that border situation is, baby. A trafficking central, honey. But the prosecutors, they overseas right now. They're over in the UK investigating alleged witnesses, victims, freak-offs, etc. And once again, there's been a lot of things that's happened since Diddy has been in jail, such as the male prostitute coming forward and bringing freak-off tapes of Sean and other high-profile figures participating in illegal drugs and frolicking and engaging, I guess, with prostitution and shit. So, there's a lot going on. Then you have all these civil suits that have taken place, like Don's, which came 6 days before his arrest, and she accused him of trafficking, underage folk. Lil Rod's civil suit, which, still has not concluded, accused Diddy of trafficking also underage folk. Tony Busby, who's representing 120 victims. Out of the 25 of those 120, they were underage at the time, some as young as 9 years old, 14, 15. I'm going to assume that if some of these individuals are now talking with the feds, and I believe that what Tony Busby said in his press conference is that some of the victims that they are talking to have been talking to the feds. This will probably come up in the court's rebuttal to this. Oh shit. Oh, okay. I had to clip my damn computer off. This is going to come up in the rebuttal, and like I said, Diddy has been initially indicted, but with this being an ongoing investigation, we could very easily see a superseded indictment, especially if they can corroborate a lot of the allegations that have been made against Diddy since the initial indictment, especially as it relates to the trafficking of underage folk, and all of this talk around freak off tapes being shopped around the black market, if those things have ended up in the hands of the feds yet, etc., who already have some freak off tapes. So this is going to be interesting, child. Let me see what y'all saying in the chat. The UK people are definitely talking about it. Absolutely. Justice for Kim Porter. Yes, God. Just pure evil. Absolutely. Not to mention the 300 or so in the UK. Yep. It is hard to tell how many people was tortured by him. Right. It's countless, because these are only the people that we know. And once again, Diddy's abuse goes all the way back to 1991, when he was just a Harvard University student. So just imagine with this man having his wealth as Bad Boy CEO and his 20 plus year, 30 going on 30 something plus years as a famed, wealthy, high profile celebrity and businessman. Just how much abuse took place within 35 plus years, because he had the means to abuse people, thousands and thousands and thousands and thousands and thousands of people. And with Diddy being as much of an attention whore and throwing these parties, I mean, how many freak offs that was not preceded by a regular party took place. As Tony Busby said, some of these freak offs didn't even take place at hotels or Diddy's mansion. Some of these freak offs, some of these SEX trafficking events took place at the private residences of other public figures. Reign of Terror. Hey Jace, hey Boo, who says, in the meantime, there is a convicted felon criminal defendant and adjudicated SAer who is, yup, pale, wrecking havoc with his lies, walking free to do his F-ish and run for the president. Baby, you better say it, Mama Jace, because this is absolutely nuts. Hell, and you know what? The defense probably should have thrown Trump ass in there. Like, y'all got Trump running for damn president, but y'all ain't gonna let Diddy out. Oh, baby, that probably would have landed, baby. That probably would have landed right there. But this is mess, and I'm a little concerned now. Because Diddy indictment hasn't been superseded yet. They haven't introduced any charges as it relates to the minors yet. Even though human trafficking can encompass that. But maybe they will go ahead and supersede it so that they can really rebut the fuck out of this third bell attempt. Howard University. Howard is a law college out of all things. Yeah, that's what I said. Howard, not Harvard. Howard University. Don't forget, all them videos starting to come to light. They are on the selling block. Yep. Just think about it. Trump was the president when Epstein was unalived. He said he didn't know him. Right. And clearly that was a lie. Diddy party all across the globe. I can't imagine how many more victims there are in multiple countries on top of the 30 plus years. Diddy ruined his kids' future. The kids can't claim him, but they are. They are supporting their father. They have been a part of all his hearings, and I'm sure that they'll be in court tomorrow. They debunked the alleged, tell-all that Kim Porter allegedly had wrote. They debunked the theory that their father is connected to her death. They stand beside their man, baby. They stand beside their man, child. They gonna claim him to the end. It's hard to tell how many people was tortured. Yep. Let me scroll up. Nope. I bet the motion for refusal of ban is already filed with even more evidence that rebuts all their statements. Yeah, it's going to be interesting to see what the rebuttal is. That rebuttal going to be some nasty work, baby. And y'all know that we're going to be here to read every word and every page of it, honey. His security guard brought land. Oh, yeah, I addressed that. Check and see if you can open the link. The file was big, so it was sent. Style drive. Let me see if depending on how big it is, because I really didn't plan on reading nothing else. I just wanted to come through on that, child. But let me see. Let me pull it up here, because we definitely are going live probably 3 different times tomorrow. We got to get into Ursha. We got to get into Foxy snatching the wig back on YouTube's girl. On YouTubers, honey, calling bluffs and things. It's just going down, Barbie. Let me see here. Oh, this is probably why I what is this? Hold on. Sean defendant on appeal from the United States Court. Appellate appendix for motion of pretrial release. So which one is this? Because we just I think I actually read this one that you sent me, Green. This was, you sent me the indictment, right? Like, this is the indictment, ain't it? Because we read this already earlier on in the situation, but I'm glad to have it her. Explain to me what you sent me. Let me see. What is the date on this? Oh yeah, I think we read this already and had this for sure. I hope the evidence seized from the raid was done so legally. Yeah, it was legal, or else that baby oil and videotapes cannot be submitted. Yeah, it was all legal, and apparently Sean was also given a heads up, which is why he wasn't home. He made sure not to be there. And the lawyer did respond to the raid. He didn't say it was illegal, but he did say that it was aggressive and he felt it was unnecessary since Diddy had allegedly been so compliant, you know, with the investigation ever since, you know, he became aware that there would be a grand jury and an indictment, etc. He knew several months out from his arrest that this was all coming. So that's their daddy. The sons know of some of Diddy's behavior, but not his daughters. And some of the sons have also been accused of attempted SA as well. He was leaving the country when the raid took place. It's going to get interesting when Foxy Brown testifies on Tupac. That will open another can of worms. Yep, all the dots gonna be dotting, child. It's 257 of y'all in the building. I mean, 257 likes. So can we get these likes up to 300, y'all? Because the nigga is working all the way into the wee hours of the night, baby. We're gonna try to do noon. I want to get started kind of early, and then we'll just, you know, from noon, it'll just chronologically, you know, happen from there. We got to get into Usher. I was going to make Usher. Initially, I was going to make Usher. I was going to run the Usher content into the Diddy content, but I'm just going to do Usher separately because that nigga is just got it going on, honey. Spooked and nervous. Okay, so we got to talk about Usher in a whole separate live stream and talk about all his damn marriages and infidelities and fucking bridesmaids and all these alleged STDs and lawsuits, and, you know, his son allegedly, his stepson being sacrificed to Lake Lanier girl. It's a mess. I pray that this judge, yeah, this interesting because they got a new judge, girl. So it's gonna be interesting. It's gonna be interesting. We're gonna report it live, honey. When it take place, we gonna report the verdict live. So y'all be looking out for that, honey. I'm gonna be, you know, keeping up with the keeping up and seeing what it gives. So that's what they proposed, you guys, to the courts. We'll see what the court signed off on. Apparently Diddy is supposed to be in court today, technically, or what it is. Hold on. Let me see. Either today or tomorrow, child. So we'll let y'all know that, and I'll see y'all at noon, child. Y'all make sure y'all subscribe. Y'all make sure y'all do the do. To be fair, if Diddy is being compliant with the feds, then he should have a fair trial. Guilty or not, we still have to have order. Yeah, everybody is due, fair and justified due process in child. You always want to incriminate people based upon the actuality and factuality, and want to follow protocol accordingly. So I agree to that. Kanye still has cases open. How come nobody talks about them? Yeah, I don't know. I think society has kind of just thrown Kanye West. He's kind of a throwaway at this point. I think people have just kind of put Kanye in the crazy box. And when you kind of get thrown into the crazy box, it's weird, because from the crazy box, you can kind of actually then really get away with murder. Because you've just kind of been considered unhinged and a detriment unto yourself, etc. And that kind of takes the steam out of the media. The media likes people who are being accused of things that have not been deemed as psychotic. Once you kind of lean into the crazy, yeah, I don't know. The media kind of eases up. It's interesting. What's going on, Gossip Girl XOXO? Hey, boo. Hey, love. A good night, real as it gets. Did he needs to drive through a sundown town at 6 p.m.? Girl, you know that I'm going to be right here on Period. Diddy, yes, God. It's going to be a mess. See y'all at noon on Period. R. Kelly didn't allow other men around, but Diddy had, because Diddy is into men as well, and R. Kelly had men around too. That's why his folk was able to all them folk was able to participate in Surviving R. Kelly-ish. His drummers, bandmates, employees, etc. Diddy was a mess, child. He liked a buffet, as he said. A whole buffet. What's going on, Valet? So we're gonna get up out of her. I gotta get back to getting my notes together for Miss Ursula tomorrow, girl. I'll see y'all at noon. Y'all have a great night. Tell me what y'all think in the comment section. Thumbs up, subscribe, donate, all that good jazz. And I'll see y'all later. Bye.